that I want to make a comment about some legislation that we have introduced actually last week that is going to be of supreme interest to a relatively small number of people. Those people in America who are general aviation pilots. And it actually affects other people too, but this is something that is very significant, and I just want to kind of talk about it for just a minute. It's important to pilots and aviation enthusiasts all over the nation, but over the course of my time, I can recall when there are so few of us that were active commercial pilots that those individuals who had problems, particularly in our state of Oklahoma, they would all come to me because they knew I had an understanding of this. And so people have come in for help. One such person was Bob Hoover. Bob Hoover arguably may have been the best pilot at his time. He's still flying today. He's in his 90s, I guess, by now. But about 10, 15 years ago, one inspector didn't like something that he did, and he took away his license. We have literally thousands of people who make their living, airline pilots and others. And in the case of Bob Hoover, he's the guy that would go up in a Shrike. Now, Chris, do you know what a Shrike is? A Shrike is a twin-engine airplane. I used to own a Shrike. It was made by Aero Commander, and he would put a glass of water up here on the top of the dash, and he would do a barrel roll, and the water would not tip over. It wouldn't leak out. This guy was just incredible. Well, anyway, it took an act of Congress that I introduced and passed to get him back into the air, and that's why this is so important to a lot of people. I never realized, even though I personally helped a lot of people who were having problems with their regulations and with an alleged offense by the FAA, until it happened to me. And when it happened to me, that all of a sudden I realized just how frustrating and drawn out the process could be. In 2011, I introduced the Pilot's Bill of Rights. I did that to address some serious deficiencies in the relationship between pilots and the FAA. There are a lot of really great people in the pilots, and certainly in the FAA. The occupier of the chair right now and I both are aware of this. In Oklahoma City, we have several hundred such people. They're easy to get along with. They're not overbearing. But any bureaucracy can have a few people who merely want to create problems and say no. So we introduced the Pilot's Bill of Rights. This was in August of 2012 to ensure that pilots, like everyone else, could be treated fairly and equitably in our justice system. I think this is probably, pilots are the last group of people who fall into that category that we see so prominently in other countries where you are guilty until proven innocent. And so anyway, we passed the Pilot's Bill of Rights, and there are a few things in there that did not get the congressional intent that was originally meant to be. And so to remedy this, we introduced S-571. It's the Pilot's Bill of Rights 2. Now it's a bipartisan thing. I think right now we're sitting on 12 Republicans and 12 Democrats that will be our co-sponsors of this bill. And there are 8 sections in the bill, but 3 general subject areas. First, the legislation reforms FAA's overly burdensome medical certification process by expanding an existing exemption for light sport pilots to include more qualified trained pilots. Let me just speak for a moment on the safety concerns. There's a small minority of people who think that expanding an exemption like this automatically decreases safety. Well, that's not true of this bill, and I have the numbers to show it. In 2004, the FAA issued a medical exemption for pilots of light sport aircraft. These aircraft were aircraft that weighed less than 1,320 pounds, had only 2 seats, and they had several restrictions. The entire country, there were about 9,500 of them. It's been over 10 years since the FAA issued this exemption, and since then, not a single accident by a light sport aircraft has occurred that was related to medical deficiency. A joint study was done by AOPA, that's the Aircraft Owners and Pilots Association, and the EAA, the Experimental Aircraft Association, on the 46,000 aviation accidents that occurred from 2008 to 2012. Of those, only 99 had a medical cause as a factor. That's less than 0.25% of all accidents. And of those 99, none would have been prevented by the current third-class medical screening exemption that was in process at that time. Now, extending that medical exemption for light sport aircraft to include planes weighing up to 6,000 pounds with up to 6 total passengers, including the pilot, would add airmen and aircraft to an existing FAA-approved medical standard without degrading or creating substandard safety. This approach has been endorsed by the Flying Physicians Association and the AOPA Medical Advisory Board. Both organizations are made up of pilots who are also medical doctors. This bill does not change the certification standards to obtain a pilot certificate, and all pilots have to still possess the pilot certificate and pass the required practical tests and flying and that type of thing. The bill does create consistency for aviators across the country where inconsistency has been felt. Now, the second thing is that, well, in fact, I would say this. We have documented cases where you have two people who had the same problem, medical problem, one in Detroit, one in Tulsa, Oklahoma, where they're treated completely differently by the medical doctors that were the examiners. This will add consistency. The second thing it does is extend the due process rights preserved in the original Pilot's Bill of Rights to all FAA certificate holders. This would be other people who hold an FAA certificate and that is not necessarily a pilot certificate. Now, when Congress passed the original Pilot's Bill of Rights, we intended to allow pilots to appeal a decision by the FAA to the National Transportation Safety Board, the NTSB, and then pilots could appeal to a federal court. We did this because a review of the federal district court is a de novo. That means that they start with the pilot getting a whole new trial, not using the same evidence as was used for the FAA and for the NTSB. Now, in two separate cases, federal district courts ruled that my original bill did not require a full hearing of the facts. This legislation explicitly spells out the option to appeal an FAA enforcement action to federal district court for a guaranteed de novo trial, meaning a new and independent review of the facts is guaranteed for these individuals. Now, this legislation also increases transparency for all FAA certificate holders subject to an investigation or enforcement action by holding FAA accountable for communicating with certificate holders. The FAA is now required to articulate a specific description of an accident or incidents under the investigation to parties involved in the investigation and provides specific documentation relevant to the investigation. While this is something that has happened in many cases, it's not happened in all of them. This bill ensures that certificate holders, these are pilots, under investigation, are afforded the basic fairness. They know why they're being investigated. They have the appropriate documentation to prepare a proper defense and can respond to FAA from a position of knowledge and certainty in all cases. I mentioned I had a personal experience. One of those, when this actually happened down in South Texas, they claimed that I was not cleared to land, and it took me 4 months to get a recording of the particular person who happened to be the Valley Approach Control clearing me to land. Now, I'm a United States Senator. It took 4 months for me to get it, and I fear that others might not ever be able to wait this thing out, and they would have lost their certificate. So, as I say, it's not a big deal to the general public, but it is to anyone who is a pilot. Now, I'm expanding the original Pilot's Bill of Rights to increase transparency for pilots and certificate holders so that they have information and resources to defend themselves if it should be necessary. Now, the third thing it does expedites the updates of the notice to airmen. A NOTAM. A NOTAM is a notice to airmen, and it's something that is the responsibility of, has historically been the responsibility of the FAA. If there is a problem on a runway that we're going to land, it's going to be closed, they're going to be doing repairs or something like that, they have to publish a NOTAM, in theory. However, in practice, it doesn't work that way. In my case down there, they claimed that there was a NOTAM that runway was closed that I had to land on. However, there was never a NOTAM, and they said that there was a NOTAM, and you just have to take their word for it. This forces them now to, in fact, the Pilot's Bill of Rights #1 was something that was supposed to force the FAA to publish NOTAMs in a common place where people would know where they are, and they just haven't done it. So now we've strengthened that to say that if a NOTAM action is not placed where it can be found, then they can't use that as an enforcement action against a pilot. So that should resolve the problem. The fourth, the Pilot's Bill of Rights 2, extends liability protection to individuals designated by the FAA, such as aviation medical examiners, pilots, examiners, and other individuals. That was the intent of the original one, but it wasn't specific. Now, this has given a lot of individuals willing to serve on as individual designees a disincentive. Now, my bill provides and removes the disincentive, ensuring increased access to medical professionals and designees to sign off on check rides and flight worthiness of experimental aircraft and all of that. So they would get the same protection. And this extends also, it's kind of the Good Samaritan law. There are a lot of times when pilots are notified, they're asked to use their aircraft to provide some worthy cause. I can remember one time down in the island just off of Caracas, Venezuela, it had been wiped out by a tornado. This is many years ago. And so I took 14 airplanes down there to help these people out. Now, if something had happened to one of the airplanes, something had happened and caused someone's injury or something, then they wouldn't be protected. They didn't have a Good Samaritan law. And so a lot of people won't do this. People have actually lost their lives because they didn't get the help of people who would volunteer their equipment to go and help people. So anyway, we have a Good Samaritan law, and that should take care of that problem. Now, I've seen many times when people are inspired as a volunteer, and I've done the same thing myself, but there's a disincentive to do that. So the Pilot's Bill of Rights 2 is sensitive to the needs of pilots, airmen, and general aviation community, and they have worked closely with me on it. Now, I have to say that the AOPA and the EAA have worked all the way through this thing, and they're fully supportive, as all their individuals are. In fact, I don't know of anyone in the aviation community who isn't fully supportive of this. So we have introduced this bill. It's bipartisan. It's something that Senators Manchin and Bozeman, they're the first two individuals because they're the co-chair of the Senate General Aviation Caucus. They're co-sponsors of this bill. So I encourage members, hopefully this is going to go to the Commerce Committee, and we'll be able to get a hearing on it very soon. And I can tell you right now, Mr. President, that the House members over there are waiting for it to come over, and we're anxious to make it to get this bill passed. I know this is something that isn't of concern to an awful lot of people in this country, but I can tell you it's a big concern to people who are pilots.